and Nairobi, bundling him into a police vehicle, bail. To deny bail, the High Court must provide cogent, the term is cogent evidence, and those creatures called agents of the respondent shouted at Integrity Center, and that's a very serious threat. They have not drawn the matrix to the so-called agents. Was it Governor Natembeya's wife? Were they governors? And this court must not listen to them. The accused person, an evil servant, he is Natembeya County. He is a deputy party leader. At the time, the so-called ghost agents were shouting, he was only one advocate, Mr. Simiu, and the rest of us were locked out. The court said that the seriousness of the offense,
I repeat, 1-1 is enough.
Lastly,
I don't know why we get this temptation, as the more I speak.
The High Court at Nairobi, criminal case number 48 of 2016, actual the High Court at Nairobi, criminal case number 48 of 2016, actual witness interference. Criminal case number 48 of 2016, actual witness interference.
That indeed, as at 6:30 a.m. yesterday, the accused person had lost by Mr. Robert Rono is certainly not accurate. Number two, Your Honor, the place where they went to play Milimani residence. what is repeated are the order that they received to search the accused's premises had the following residences. Kibomet.
Come again.
First is
No, the second.
Second is a place called Kibomet. Kibomet. Third is Nairobi. Residence in Kileleshwa. Okay. Were vandalized when they were searching his guitar. Your Honor, looking at the order, which Your Honor you can have a look at. We are appealing to that the evidence that has been annexed to the affidavit is illegally obtained. 5. To the Evidence Act, Section 106, capital B, Section 4, subsection
Record. You're on the 6th minute. The 6th minute.
I wrap up here. Please refer to the
You read it reason.
I yield, Your Honor.
Honest to record.
Thank you.
Your Honor, I tried to say 3 minutes at max, and you stopped me with 5. There is no certificate of electronic evidence annexing those pictorials. I didn't think this.
Slow. You left me a mile to go. Their applications contain in
And in the absence of the electronic certificate, the annexed Section 3 of the Judicature Act lists the sources of law in Kenya. That this court is called up. when we say the court to apply Article 49, to apply Article 50, we are asking the court to apply remaining constant, the right to bail is constitutional. And the purpose of giving terms is to compel attendance. Detention should never be used as a basis to punish an accused person who is still presumed to be innocent. Whereas they
And Jerry, your last soldier. Is it your last or?
This one and then
Dr. Amino.
thank you, Your Honor. Your Honor, I'm very privileged to appear before you to demonstrate that what I did recently in my second PhD in criminal justice. I would like this court to look at the whole history of the government and intergovernment officers calling themselves ES. Law whereby if the government raises its own legitimate expectation, if that was the case, then that law must be narrowly, and I mean narrowly tailored. How do we look into the classification of what the state has alleged? Classification, looking at the time to drive, the time taken to drive the accused, the miles involved in that journey, and how the accused was arraigned in court. Lastly, and please let the court make me understand whether the arresting officer is the investigating officer, and is the judge. And even if that statute contradicts the Constitution, in which case I believe it does, following the circumstances. I think it should, because I can substitute it. Your Honor, what I mean by literacy is not literally. Raises issues that can only be raised on discovery. Thank you.
Thank you.
My grandparents in Sundupi, I always appear with them in the cases. Like only one word he wants to tell you. Only one word.
The one word will take maybe 1 minute or less. First, we look at the charge sheet. Particulars refer to one. It is impossible to tell which one we mean, except for the use of the word God. Related to that is particulars in the charge sheet under the law. I make the presumption that the court knows how to do that, right? And understand those particulars. Which are suggesting that he has committed an offense of corruption. Of conflict of interest. The particulars of conflict of interest have not been indicated. So that's what's if you look at count 2, same problem of lack of particulars. So there is not no evidence that demonstrates we were told monkey see, monkey do. When the government itself mandates court orders, citizens have no reason to. I do recall off the top of my head, the governor of was it Istanbul who was charged with the court has authority discretion to give conditions that will ensure that the proceedings of this court are
because several counsels or advocates have spoken. They have made personal submissions. I would respectfully argue that and you tell the audience that a written ruling will be delivered much later. By the High Court. This has always been done by the Court of Appeal.
This one?
Giving reasons later.
Yes.
Has always been done by the Court of Appeal that the government is free, forceful, and you will deliver the ruling later. I also argue very, very respectfully to the nation, and there's no way you can be in Kenya for another country at home. Give them a free fall, and you will also be etiquetting certain people and certain people, saying to you respectfully that you make an order before you rise.
Sorry, that is called, and it's okay.
That the governor should be released on a free born.
You're a child of
Born in the colonial days.
colonial days.
I'm the child who received education in colonial institutions. Of sociology, anthropology, philosophy, when we had terms like the African mind, how the African thinks, and so on, from the colonial. There's one thing I can make you very clear. The criminal law of Kenya has always been during the colonial days. It was abused during Mutembei Kenyatta's days. It was abused during the Patrick's reign.
I think the statement is on the child. The statement is home.
They have now taken over the criminal law of the country. They are abusing it. The rule of law, which we thought was improving, is now in ICU. That unless we arrest the situation, nobody will have confidence in the country. The country could easily be classified as that it can come to.
Daktari, if we can deal with Mr. Natembeya first.
Your Honor, what the charge that you are given here, one can even pass this blood. The first comes. The governor is supposed to have corruptly received the sum of shillings. One can see that this is dishonest. Dishonest. The country because of that amount of money. That's on the first page. What is that? A full governor, 2 million. On the 68th page. Sadly, Your Honor, proposition is 1.2 here. A constitution must be meaningful. It must develop something called content. In some cases, something called convention. You would expect that a charge against a governor of the country, the director of to satisfy himself that a case has been made out against Natembeya. Having regard to what we have been told, it was realistic to win. When did the DPP read the entire file? At least if I may say in favor of Charles Johnson, he would read the entire file to satisfy himself that indeed a case has been made out to millions of people. It is therefore not surprising that the people in his own area were mad to him trade at home. Your Honor, may I say draw your attention to the fact that I also have noticed entertain the count There's no jurisdiction at all. But a charge can be preferred against the governor. The way to deal with the governor is to use impeachment proceedings that have been provided for in the Constitution. The governor. Releasing. Jonah. One final question, one final submission, and then next to you. Please don't misunderstand me at all. What is required of a lawyer? What is required of a magistrate or a judicial officer? Is to be strong and to be courageous. Might in your very structure that rise to the occasion. The country has gone down. And you need young people like yourself, John, who have got power, to see whether we can bring up and maintain the concept, let the executive keep its own base, not to get into other bases. Currently, it is not doing so. Other quotas and so on.
Mahatma.
Yes, there is a book here which we refer to impeachment in the Nigerian presidential system. That's why we have a lot of impeachment for governors and so on. And I've noticed that the order for this book.
What is the title?
I'm taking the title. It's impeachment in the Nigerian presidential system. I assure the very learned senior that we have captured.
Yeah, there's a lot of issues on impeachment. They would rather die than have such a government in power. Just as some people, I'm sure, are swearing that they would rather die than see Governor Natembeya in power.
Very well.
Our father.
The father, the profession, he has said it all. Give the governor free board at the very worst. So that we don't play in the hands of his tormentors. Let there be no condition. This man has been elected by his people. He has committed no wrong until that effect. So let's not talk about conditions. In fact, that bridge, you want to please expand it. I plead with you. Expand it. Let him get his free vote or cash bill, let him leave. Even if he believes. We believe Your Honor, you do the right thing. We have no doubt at all. I, for one, have no doubt. I know you are a good judicial officer. You believe in the rule of law. That David George Natembeya will walk out. No conditions have been sought, and he shouldn't even be there anymore. Let the man go and serve. He'll have his day in court. Thank you.
So, Ian, I'll start with the jurisdictional issue that has been raised by counsel. Especially the very learned Dr. Amino, as to whether or not this court jurisdiction to entertain these charges. And that is related to reference, I believe. I haven't made reference, but I believe that's the position. You are in brief responses. This court's jurisdiction to entertain anti-corruption matters is provided of the ASECA. ASECA is a law. Point of law is ASECA. So this court has jurisdiction. The Director of Public Prosecutions is vested with power to institute criminal proceedings allow me to make two. Number one, I don't know whether counsel read the charge sheet. Count number one is conflict of interest. And not just that. Count number two. How could he have second correction here. My learned senior, Mr. Masharia, if I don't situated within the Republic, unless we are reading different ones. So but even the search in Trans Nzoia was by law. It was sanctioned by law. The arrest was proper. The searches were proper. The to ensure and promote an equal application. Ensure and promote an equal application of the law to everyone. Of the law to everyone. Equal application of the law. Article 27, sub-article 4. Equal application of the law. Article 27, sub-article 4 of the Constitution. Of the Constitution. Properly, on the basis of which properly, on the basis of which it would institute these proceedings. institute these proceedings before you. I withdraw.
If you have withdrawn, I wanted to clarify that.
I scored it differently, so I withdraw. Your Honor, back to the question of bond as I conclude. Page 19, reported in the Kenya Law Report in 2010. Republic versus John Kahindi and two others, 2010 EKLR. It is at the footnotes of page 19 of the Judiciary Bail and Bond Guidelines in opposition of bail. Anyone can confirm because the guidelines are available online.
But the prosecution
does not need to avail an affidavit in support of an application for denial of bail. While other courts insist on it, not all courts insist on it. That's the import of that decision. It's cited at page 19 in the footnotes. The importance of that argument that we make is that even without an affidavit, compelling reasons can exist. And so that the argument by Mr. Otieno that if certain documents were removed or expanded, then there's no basis there's also the argument as regards bail that we have not.
you can't admit that no, your pace, not abilities. I'm not doubting your abilities. You underestimated your pace.
Thank you. Your Honor, I was referring to. Did I say last? Thank you.
Last, you were attacking the challenge by Mr. Otieno.
All right, yes, thank you very much. So Mr. Otieno was of the effect that if there is no certificate under 106 Aminwa, in Mr. Ichesa's words, the first accused is a governor of a county. And he is not a lonely man. Verbatim, if I got it right. objecting on? Is it points of law or what you say?
As in, you have quoted my statement in my presence.
Yes.
You clearly misunderstood it, and you want to go to the next person without clarifying to the court.
Sorry, Your Honor, I have not wrong in my interpretation, but in hearing you, I can't be wrong.
Points of fact, points of law.
Your Honor, I'm coming to the point of law. I'm still quoting him. You cannot be the point of law. I'm coming to the point of law. And thirdly, I am reminded that my very good friend, senior Dr. Ndu, that the influence of the first accused is admitted by his counsel on his behalf, and that it is not far-fetched that of the judiciary bail and bond policy guidelines talks about likelihood. Yes, Your Honor. I am done. That is my last point. Influence, there is a compelling reason you must deny bail. And standard of proof is on a balance of probabilities. I thank you for being patient with me. I am such a mouthy, and we urge you that we have established compelling reasons to deny the first accused bail. Thank you, Mr. Your Honor.
Your Honor, the permission to you add one of my colleagues who came in late. Honorable Jeremiah Kioni, Social Counsel, who will listen on record. We now able to come to do the right thing.
It's now you are ruling on the matter. I possibly need one, we take a lunch break. So the issues are into millions. I will try the best to do it in 1 hour. encouraged me to, unfortunately, we have not been facilitated that way by our procedures. For the Court of Appeal, for the Supreme Court, they are facilitated properly by that actually can give ground perspective of my abilities and competence, which I do not wish. So we take a break. We resume at exactly 2 for the ruling.
Much obliged, Your Honor.
Good morning. Welcome back. You're still watching Daybreak on this 20th day of May 2025. In studio I have Geoffrey Wandeta, who is the Member of Parliament for Tetu constituency. I also have Kabala Kile, Deputy Chairperson of PLP Party, People's Liberation Party, right? Great. Senator Veronica Maina, nominated Senator of the UDA party, the governing party, and also Professor Maxwell Miyawa, International Development Law scholar, and also teaches at the Kenya School of Law. Before we dive into the conversation, there's a story that I want us to take a look at, which is about the High Court has suspended the vetting of nominees for IEBC chairperson and commissioners that was due next Monday. Justice Lawrence Mugambi issued the orders after lawyers representing petitioners Kelvin Roy Omonde and Boniface Mwangi warned of the risk that the National Assembly may proceed to vet and approve the nominees in the absence of orders. The orders will remain in place until the 29th of May. Attorney General Dorcas Oduor, who filed a preliminary objection on the case, says the court lacks jurisdiction to hear the matter. IEBC nominees face another case filed by civil society outfit Operation Linda Jamii, who argued that the nominations are made without the necessary political consultation. The case is due for further direction on the 11th of June after petitioners serve respondents. All right, and of course, that is one of the stories that has been featured in the dailies on the 10th page of the Standard. They are talking about High Court holds vetting of Ruto 7 IBC picks by Parliament, and some of those in the matter. We are raising the issue of 5th Commissioner Hassan Nur, who was not shortlisted in the initial process. He was not in the advertising list made by the selection panel. That is according to lawyer Paul Moite, and it is also one of the stories. This is on page 2 of the Daily Nation, that court blocks Parliament from vetting Ruto's IBC nominees. I'm just wondering, Senator Maine, if I may begin with you, and I know the Justice Legal Affairs Committee was expected to start processing these nominees. Does that court order stop the House knowing that it has its own rules and procedures?
The House, it's an interesting question because the House does have its own procedures that govern the running of Parliament. And you know, the three arms of government are independent of each other. So, like the process of Parliament can proceed on. Obviously, the challenge then becomes when a court order is issued and it's supposed to be obeyed. Then the challenge comes in as to whether that court order should actually govern what happens in Parliament. And obviously, it's always good to abide by the court orders. But what we must look at is how the court gives those orders and